Today we are going to discuss an adjustment of status I-485J 180-day rule. This is when people transfer from upgrade from Eb3 to Eb2. We're going to also discuss about the how to read the processing times. USCIS have now changed the processing times, and I think so it requires a Ph.D. from USCIS to read the processing time. I think so we may come close to it. We'll see what we know about how to read the processing times. We have seen some increase in the 221Gs from US Consulates in India. Just want to give an update on it. We also want to give an update on America Competes Act, and if there is an immigration provisions, what will there be in it. We're going to discuss about PATEL versus GARLAND Supreme Court decision, what impact it may have on our employment-based immigration. Emily, as you know that most of the people have filed the 485 application in October, November or December of 2020, and at that time they downgraded the application because USCIS and the State Department thought that the visa numbers available in EB3 but not in EB2. All the people downgraded, and then they realized, oops, there are not many number of applicants in EB2, so they requested all the people to upgrade it, and they have given a special address to upgrade it. But they put a special rule of 180-day rule. Now, can you explain where does this rule come from?
Yeah, so I think what USCIS is envisioning when they came up with this rule is, at the time you filed in October 2020, for example, the EB2 date was not current. So you could not have filed the 485 based on your EB2 I-140 at that time. Now that the date is current in EB2, they treat it as if now you're just now eligible for EB2. So that means the regular rule of AC 21 is 180 days from the date of filing the EB2, which is now, even though your 485 was actually filed in October 2020. I think that's their thought process behind it. It still doesn't make any sense because it's the same labor, it's the same job.
So Emily, now let's look into the reality aspects of it. For example, if I'm working for Coca-Cola company, now I want to move to Pepsi, and I have downgraded from EB2 to EB3 in October. I'm contemplating on moving to Pepsi. What should I do? Should I file the EB3 to EB2 conversion, or should I wait my 2014 priority date come up in EB3? What should I do?
Yeah, and that's really tough because the job market is crazy right now. There's a lot of opportunity right now, and I think a lot of people feel like they'll be missing out if they have to wait, which they've waited so long. Why should we have to wait anymore? So you could consider going ahead and doing the interfiling to EB2, getting that supplement J from the current employer that has filed that I-140 petition, and then trying it out. If you change jobs, I think the worst thing that would happen is USCIS would say, well, you didn't qualify for AC 21 yet with respect to your EB2, but you did for EB3, so you're gonna just continue in EB3. I don't think they could flat out deny the 485 for that. Seems some people are getting approvals based on EB2
yes.
in this situation. And it's very unclear. I've actually seen RFEs where they tell you, number one, they want you to submit the supplement J, but they specifically reference your EB2 I-140 approval from 10 years ago.
Even you never filed the 485 in EB2?
Right, never even submitted it, but they're still referencing that other I-140, so they know you have it. But then in the second bullet point, they're saying, oh, and by the way, you can transfer the underlying basis from EB3 to EB2. So if you put those two together, it would make it sound like you can submit a supplement J to move to a new employer using your old EB2 I-140 and transfer the basis to EB2 at the same time. I don't think that's what they intended, but that's what the RFE suggests. And I know people have responded to that in that way and got approvals. Yeah. So maybe we're being a little too strict, and we should be more aggressive in how we're responding to these. And if they're going to open up the door and say, hey, give us your supplement J and let us know if you want to transfer the basis, well, let's just do it.
Yep. At the most, they're going to stick us with the EB3. So, Emily, in situations where people are moving from Coca-Cola to Pepsi, and they file the 485J supplement, they are moving within 6 months to Pepsi, would you request them to have the Pepsi file a 485J supplement after they just transfer to Pepsi, or would you tell them to hold on it?
Yeah, I would definitely wait, because there is no requirement to proactively submit that supplement J, even though in our normal circumstances we would do it a lot of times right when you make the move to avoid an RFE on it later. But in this case, you don't want to unnecessarily trigger something. So I would hold off on that and probably not submit it unless there was an RFE or I got called in for an interview.
Questions with regards to the processing time, Emily. Now, what's this? Previously, there used to be 2 processing times, the minimum and the maximum, and now it seems to be there's only 1 processing time. Mm-hmm. So previously, they said that the least one, let's say for example, it said 485 processing time in Texas Service Center. Let's say it says 12 months to 19 months. The 12 months was 50%. That's what they said. It was not. The timing is a little bit different. And then 18 months was 93%. Now what's changed right now?
Yeah, so now it's just one date, and that's the date where 80% of the applications have been processed in that time period, but they're only looking at the last 6 months of cases that they've adjudicated. So they're kind of trying to hide all of these long pending cases.
So you mean to say the black hole cases that we filed in October of 2020, they don't want to show it to the congressman?
Exactly.
So if my application is beyond the processing time, can I raise a service request right now?
So if it's beyond this 80% processing time, then you can type in your received date of your case, and it will spit out a date when you can submit a service request. So you may or may not be able to.
So that processing time is for the congressman. For our clients, that doesn't work.
Yeah, yeah.
Okay, so please keep writing the letters that we have drafted, guys. That's only way we can. Now, I just want to inform the audiences that there have been an increase in the 221G from the request for additional information from US Consulates in India, especially those people who are going for Dropbox. They've been called for the interview. They are getting a lot of they're getting a lot of 221Gs right now. So be prepared to stay for a long period of time, even though you are Dropbox eligible there, though.
And have you been noticing with those 221Gs, are they ever requesting any documents?
No, most of the time, none, Emily.
Yeah,
it's
mine
just
either.
an inquiry. Can you update about America Competes Act? I know that in the House provision, they said they want to exempt some of the PhDs from the numerical limitations, special STEM degrees, PhDs from the numerical limitation. Is there any update from what's going on in the Senate, Emily?
Yeah, so we do have a version that passed the House that does include immigration provisions. We have a version of the bill that was passed in the Senate that does not include immigration provisions. So when you have 2 different versions of the bill that has passed both houses, now they have to come together in a conference to work out their differences and come up with a final bill that everyone can agree on, and then both houses one more time vote on that final bill. So we're right now in this conferencing stage, and you have a lot of senators that are saying, this has nothing to do with immigration. We don't need any immigration provisions in this. That's a separate issue. Yet, anytime there are other issues like high-skilled immigration, they want to club it together with border security and enforcement and all of that. But when we want to put it together with the economy and dealing with China and those sorts of things, oh, it needs to be separate all of a sudden. So I don't know what the final bill is going to come out to be. I think with the Senate, probably doesn't look good that it's going to include any immigration provisions, given how they can't seem to get anything through the Senate with immigration right now.
Emily, we've been waiting for a long period of time for the Supreme Court decision of PATEL versus GARLAND, where the question whether the federal courts can take up the immigration decisions and review those decisions, though. What is it, a good thing or the bad thing what Supreme Court gave it to us?
I think that if it had gone in our favor, there were things that could potentially help employment-based cases let me say this decision is nothing related to employment-based immigration.
But overall, it's definitely not good for us to.
Right, yeah. So it had the potential to give us some good case law that could help us with our delay cases, especially with these 485s pending that they're saying we don't have jurisdiction to force USCIS to do something. Well, in this case, the court said we don't have jurisdiction to second guess the fact finding of the lower court. So because they're choosing not to use their jurisdiction there, it makes our argument that we were hoping to use weaker on the employment-based side. But the case itself had nothing to do with the employment-based. It was very limited in its decision. It was just talking about in discretionary types of findings where removal cases particularly, the judge can't go back and second guess a fact that was found during the lower court process. So there's no jurisdiction, basically, was what that came out to be, which we were hoping it would go the other way because it would kind of pave the way for some novel arguments in the employment-based cases, but unfortunately it did not go that direction.
Let's go with some of the updates before we go to questions. So we got some people saying that some advisory commission has unanimously voted for the 6 months adjudication of the 485 applications. This is just some committee, guys. Just imagine that. If we all agree, I mean, we are about thousands of people listening to us, we all agree and we say, okay, let's pass a resolution among ourselves saying that we should recommend USCIS to have adjudication done within 6 months. The yeas have it, the yeas have it, the yeas have it for sure. I agree, most of the people will agree with us. That doesn't mean anything. This is just an advisory committee on not even immigration. This is Asian American, Native, Hawaiian and Pacific Islanders. They don't care about these resolutions though, even though it's a major newspaper that published it. That's just to attract the Indian nationals, but it doesn't do anything good for us. At this point of time, you still continue writing the letters. That's the only thing that can do it. These other advisory committees are very good. They're absolutely, I'm not telling they're not good, but it just will not have any significant impact. Do you think so? These advisory committees will not have?
No.
Okay. I want to give some updates which we commonly come across. That's what we are starting from this week. We are receiving 485J receipt notices for the people whom we have filed for upgrade applications that we started filing in January of 2022. We're receiving the 485J receipt notices. Also, we just want to inform you that there are some cases where people have received the 485J receipt notices and they are getting a notification on the online status that because of the visa numbers not available, they are not adjudicating your 485 application. What do you do at that time, Emily? They have filed 485 under EB3, they have filed the upgrade in EB2, but they gave the 485J supplement, but they're still saying that the visa dates are not available.
Yeah, it doesn't make any sense because they obviously know that you have used this interfile process to transfer your underlying basis from EB3
You mean to say
EB2.
they know what's in the right hand and what is in the left hand of them, Emily?
They should.
Okay, come on.
But what it tells us is that they're still considering these cases to be in EB3. And so my concern is, are they really pausing work on them because they think they're in EB3, even though they're eligible for EB2 and have followed every single step USCIS told them to do? So we're trying to figure out what's going on there because we've both come across it in multiple cases. It doesn't look good for all the interfiles that were done. So how do we get the attention of USCIS to make sure they understand these are no longer EB3 cases? They should be EB2 cases. Final action date is current. You can adjudicate. You should not be pausing work on these cases. So we have a couple of different options that we're trying. We've recommended to some people to try to use the Ombudsman office by filling out the DHS 7001 form. I've also recommended contacting the congressman or senator's office in your area for assistance with a federal government agency. That's kind of where we're at right now. It's possible it's just a glitch. We just don't know what's happening, but it's definitely not a good sign.
And a couple of updates that I want, commonly asked questions that we get in the past 1 week is that normally when you file for H4 and H4 EAD together though, most of the time you will get the H4 and EAD approved at the same time. Just want to let you know on that. A quick update with regards to the Margarita magic, where we say you go to Mexico and if your spouse H1B is approved, you come back. They will give an I-94 extension until your spouse H1B approved. Previously, 95% of the people used to get the I-94 extension because that will make them eligible for the 540-day rule. Recently, though, we have some setbacks. I just want to inform you about it. That I would keep the percentage of the people who are getting the I-94 extended to about 80 to 85% based on the recent updates. Emily, there are some concerning questions that I have. We have advised people on H1Bs, they can do multiple jobs. We have advised people that on EADs that they can do multiple jobs. But when it comes to the AOS interviews, though, the USCIS officers are unable to understand these people can work for 80 hours a week. I mean, most of these USCIS officials are, lazy workers. They can't even work 40 hours properly, and they can't even imagine people can work for 80 hours. What is the solution when these people go for the interview?
Yeah, I think if you're in that situation where you have worked multiple jobs, I mean, it's completely legal to do. You have the employment authorization either through the EAD or if you did the concurrent H-1B filings. But you may want to consider bringing an attorney with you to the employment-based green card interview, because these officers, as you said, they just can't fathom that someone could work two jobs at the same time. And the interview just goes south very quickly. It becomes very aggressive and argumentative, and they just don't get it, even though everything is completely legal to do that. So you may want to consider bringing an attorney with you to your interview if you're in that situation where you have worked multiple jobs or you're currently in two jobs at the same time when you're called in for the interview.
The lawyer can clearly explain, look, dummy, there is a provision in the H-1B itself. There are boxes. Is it a transfer application? Is it a new application? Is it concurrently filed H-1B? That's a whole column for concurrently filed H-1B. And we have to explain to these things, especially in medical professions. So we have seen people working for multiple jobs. I mean, at one point of time, we have done for a dentist, he has 6 jobs. He's working on different things. That's perfectly okay to do that thing. The lawyer should be able to explain that very clearly. If there's an interview, you may want to hire a lawyer to go there and explain these things to the people, though, to the USCIS official. Emily, what's the reason why in your blog of Immigration Girl of Adjustment of Status, where you are posting from a immigration lawyer's desk, I see most of the cases that are approved in May are actually filed in September 2021 or afterwards, while the October 2020 are still pending.
Yeah, there's no good reason for it. I mean, it should be first in, first out. Obviously, priority date should also play into that, but the priority dates don't even make any sense in terms of what they're doing. And we do see this over the years, this trend when they get a big backlog of cases, and to try to clear the backlog, for some reason they work at it from both ends instead of continuing the first in, first out and trying to ramp up to be able to adjudicate the earliest filers first. They start working on the latest filed cases and then kind of slowly work on the earliest ones until they clear it. And they've done that many times. We've seen it when I-129s got delayed, when they had a backlog of extensions several years ago. At one point, I-140s were delayed because they eliminated premium processing at one point. Same thing happening with I-539s. We've got some that have been pending for a very long time, and then others getting approved in 4 months. They're just not sticking to first in, first out. Unfortunately, that's just how they operate nowadays.
Just want to update for the PERM applications, guys. What we noticed in our office in the past 1 week, the approvals are from November 2nd week to November 4th week is what we have noticed. There are some cases that have been filed in October last week also that are getting approved right now, but we haven't seen any cases that were been filed in December of 2021 that got approved this week. We're going to keep updating this every week, guys. Emily, with regards to the June visa bulletin, though, what are your thoughts on it? Why did not they move the filing dates. Why did they move the final action dates for Eb2 were advanced, and USCIS is not even accepting the filing dates. That means that what they're accepting in this month, which is December of 2014, they're not accepting. It's only until September of 2014 they are going to accept. What is your thought on this one? What do you expect in the coming months, though?
Yeah, I think that's definitely unusual. Now, this year has been unusual because since October until now, we've been able to use the filing dates every month, and that's never happened before. Usually in the past it was October, November, December, then last year it was October, November, December, January. Now all of a sudden we're into May, and we've still been able to use the filing dates until June. So that suggests if USCIS is not allowing us to use the filing dates, they're throwing their hands up and saying, don't send us any more cases, we've got enough work to do. We're not going to get through all that we already have. That's just what we're expecting to happen. But I think it's because USCIS can't take on any more work, or that's what they're
You mean to say they've given up on the
exactly.
things, though? So with regards to 6 months promise that by September of 2023 they're going to go to 6 months, do you believe they are going to be correct?
No.
Okay. So
Well, maybe under their crazy new processing times.
how we read they're going to change. They're not going to change the processing time. They're going to change how to read the processing time.
To make
in that way, in that way, they can say that the processing time has come to 6 months. Definitely, it seems to that they've given up on it. I don't want you guys to give up on this. Remember that last year, at the same time, you have put a lot of pressure on the 485 applications, though. In the last quarter, they adjudicated more than what they adjudicated in the first 3 quarters. If you keep writing the letters to these people and you keep a pressure on these people, we may be able to get a most out of them. Otherwise, we may lose more than 150,000 green cards that should have belonged to Indian nationals, to some extent to Chinese nationals. So keep the pressure on, guys. Keep writing the letters to the USCIS. Question with regards to, we're going to go to question and answers. Srinivas Bolam, has anyone ever filed an immigration petition on your behalf? That question comes in DS-160 form. Definitely, if you have an I-140 approved, you should answer yes to that question and just mention to that your Eb2 has been approved and give the file number to them. If you're applying in the DS-160 form for H1, H4, L1 and L2, if you have an I-140 approval, if you answer yes and give it, it will not have any negative impact whatsoever at all in getting your H1B, H4, L1 and L2 approval.
Abhijit wants to know, now with the 540-day extension, is it kicking the can down the road and we still won't have an EAD card at the end of the 540 days?
Oh, come on.
Yeah, I think that's exactly what it is. You know, I think maybe they'll be able to clear out some of it because they'll be hopefully approving some green cards and people won't need the EADs. But I don't have high hopes given what we've been seeing for the past several years in these processing times. They're just buying time.
Can we respond to the RFE after the due date based on the USCIS COVID flexible extension of 60-day rule? It will be denied. This question from Katta Kiran. Yes, you still have the 60-day extension rule. You can still file the RFE response after within the 60 days after the deadline is over. It's perfectly allowed. They will not deny it.
Madhu says, can we submit the medicals along with the Eb3 to Eb2 interfile? No, I would not recommend it. And the reason for that is your Eb3 to Eb2 interfile goes to that California Western Way Form Center. Your file is not there. You need your medical to actually get into the file. So you need to send that separately to the service center where your 485 is currently pending. The interfile process to transfer the underlying basis is a completely separate process, so don't mix those two together. Vedant says, can I change from Eb3 to Eb2 with the same employer and the same job? I never had Eb2 before. Generally, no. That only works if your labor certification was filed for the Eb3 position was for a master's degree or bachelor's plus 5 years of experience type of position. Usually in that case, they would have filed at EB2 at the I-140 stage. So most likely, if you're a regular EB3 where maybe your job required a bachelor's degree or 2 years of experience or something like that, it's not possible to use the same labor certification to now file an EB2. Your company has to go through the whole labor certification again for a different position that has a requirement of at least a master's degree or a bachelor's degree plus 5 years of experience. Then once you get that I-140 approved, now you've got 2 jobs and 2 I-140s based on 2 separate labor certifications.
Maruti, my friend has an I-140 approval. Later on, he accepted a remote position though. They start a new labor certification. Can he not file 485? Can he not file a 485 using the old I-140 approval? Absolutely they can. I want you guys to be very careful when you communicate with your immigration lawyers. Maybe the company's office at a later date. You do not have to file the labor and I-140 again. And that's where the communication is. Let's say, for example, you have a job in California, and let's say you have a job in San Jose area, and now you took a remote job in Austin, Texas. Your labor certification is in San Jose, California. You moved remote job in Austin, Texas. If your intention is to go back to California at a later date, you do not need to file a labor certification. You do not need to file an I-140. You need to file a H-1B amendment, but you do not need to. Under your conditions, Maruti, what your friend's condition is that if their intention is to go back to California, then it's perfectly okay. Now, people ask the question, well, after I get the green card, what if I don't go to California? Will they cancel the green card? Will it have any trouble for the citizenship? It's only the intention until you get the green card that counts though. After that, if the intention changes, it's perfectly okay. Nothing is going to happen to your green card. It is very similar to your New Year intention. What is your intention in the New Year? I am not going to eat any fried, period. Okay, that's what we decide on January 1st. Guess what happens on January 5th? Oh, this is okay. I'm going to eat one piece. And you know what happens by January 15th? We break the whole rules. So if you do such kind of things though, after you get the green card, absolutely no problem with it. Do we see any problem with it? No. So it's the intention. But if you keep on expressing your intention, no, I don't want to go to San Jose, California because it's $2 million per a home there. Its taxes are too heavy. The traffic is, I don't want to go there. Then of course, we don't have any option other than becoming rich at your cost.
So Sheil says he interfiled to the California address 6 weeks ago and now has received an RFE from the field office to provide visa documents. And he wants to know, is it a good idea to send a copy of the entire interfile in the 485J to the field office along with this RFE? I do think that's a good idea. I've got a couple of cases I'm working on very similar to that, and I do plan on doing that because the way that the RFE came, it makes it seem like they have no idea that the interfile was even done. So I am sending in those same documents explaining that, hey, the priority date is current in EB2. Please adjudicate this in EB2 so that there's no question. I'm including the visa bulletin and circling. I'm including the I-140 approval, the 485J, 485 receipt notices, everything I can to get them to make sure that they do have this in EB2 so they can adjudicate it.
Raji from YouTube has this question, very interesting question. Can I apply for a H-1B extension, go to India, re-enter on AP without impacting the H-1B extension? The new guidelines of the USCIS is very clear, under which you will not be impacting your H-1B extension. We have filed a very similar situation. We didn't have any problem at all. You can re-enter an AP, they will extend your H-1B without impacting your H-1B.
Srilatha downgraded to EB3 in 2020. Date is current at EB2, but already moved to a different company and wants to know, can I file the 485J and interfile using that EB2 with the new employer? So that's where it's just completely unclear because we've never been in this situation before when the 485J was implemented. So the 485J has only been around since 2017, and we have had these downgrade upgrade situations many times over the years, but not really after the supplement J came into play. So we're kind of making things up as we go at this point and trying to predict what we think USCIS will do. I have seen cases where people submitted the Eb2 I-140 from the old employer, the supplement J from the new employer, and requested to transfer the underlying basis, and USCIS approved it. Now, is that going to keep happening? Was that just a one-time thing? We don't know. But the worst case scenario is they would just say, well, you don't qualify to do that, but you do qualify for AC21 and EB3, so you'll just stay in EB3. So it's not like they should be denying your 485 for doing this, but we have seen some people that got it.
Harsh wrote letters to the congressman, thank you very much. Can the H-1B extension be filed 2 months after the H-1B identifier expired and the beneficiary left the United States? You can file it. The wording you're using is a little bit wrong. It's not called as an extension. It's just called as an H-1B. You can still file a H-1B after your identifier expired and you left the country, you're outside the country. We do this a lot of times, especially for the people who are getting near to the 6 years of H-1B. What we do is that we tell them to leave, and once the I-140 is approved, we file after 2 or 3 months. Well, after they left the country, we file the H-1B and we bring them back. There are many different scenarios where we can do the same thing. But the wording that you're telling is extension is a wrong word, but otherwise, yes, after you leave the country, you go there, you can still. Now, once you've been counted towards the cap, if you have not completed the 6 years, or if you completed the 6 years, you have an I-140 approval, you never need to be counted towards the cap. Whether it's 2 months, 3 years, 10 years, 20 years, you can still get the H-1B filed and come back into the United States on H-1B.
Amit says the EB2 date is July 2012, filed the 485 in November 2021. Cases at the NBC, EAD, and advanced parole are approved. Can you suggest when my 485 will be adjudicated? So we are seeing approvals from cases that were filed at the National Benefit Center standalone in EB2 that were filed October, November, December, January. Even February 2022 cases are starting to get approved. So it could be any day now. It could take longer than that, but we are seeing approvals from that November 2021 timeframe as your case. Chirag has this question. His prior date is April 2013. His case has been transferred from NBC to Nebraska Service Center. Is that a good news or bad news? Definitely not a good news because the USCIS is not adjudicating the cases in Nebraska Service Center unless they are already in the process of adjudicating it. So definitely not a good news. Gaurav says his case remains pending, but the application was put on hold, but the priority date is current. What can be done to resume processing?
So many people are asking the same thing.
Yeah.
Pooja Jain is asking the same question.
Yeah, and this is a new development that we've just started seeing within the last week here. So we're trying to experiment and see what things are working and what isn't working. We know that it's practically impossible to talk to a live person at USCIS. The Emma chat doesn't seem to be working lately. So we're trying the Ombudsman Office, the DHS 7001 form that you can fill out online, and also your Congressman or Senator's office. Now you can't do both of those, so pick one or the other. I've also raised this with the American Immigration Lawyers Association to see if maybe their liaison with USCIS can figure out why this is happening and get us an update there. But please update us if you have any successes after trying these things, and we'll definitely update you next week if we hear back with anything that's working to get these cases unpaused.
LA, quick question. Got an RFE for I-485 requesting evidence for the proof of marriage. Is it normal? LA, that is a very good news for you. I mean, when those kind of RFEs are coming, it's very, very good. All you need to do is that provide that you and your wife are living together. Those are very normal RFEs, and you respond to these RFEs, you have a very good chance that the thing will be approved very fast. why do they even send these kind of RFEs when we have two kids? One is 16-year-old, one is 8-year-old, and we are living together. Well, the USCIS officials have a quota. They need to issue certain RFEs. This is the easiest RFE that you can get it. I mean, you can easily provide the documents that you both are wife and husband, like lease agreement or mortgage, car insurance together, medical insurance together, utility bills, phone bill together when you have a family plan, all those things. Some pictures, normally take the pictures along with other people, children's birth certificates, submit all those things. These are easy to get documents and easy to get approval. And yeah, open, buy a champagne bottle and keep it if your final action date is current, because you may get the green card soon and you may want to open that.
Vishal says, in the LCA, there's a 40-hour work week mentioned. Can we work more than 40 hours in the case of an emergency issue? I'm the IT guy. If yes, what is the maximum number of hours we can work? So there is no maximum, and you can work more than 40 hours, even though your LCA mentions full-time or 40 hours a week. What the LCA is kind of the minimum, so they don't want you to go below 40 hours. They don't want your salary to go below the amount mentioned on the LCA, but the salary can be higher, and you can work more hours, no issues at all with that.
Ajay has this question. He has filed the 485. He as a derivatory, his wife is a primary. Am I allowed to file a new 485 application, him as the primary and she as a derivatory? Absolutely you can. But for doing so, that you should have maintained the non-immigrant status. If not, there are some margarita things we call, and you can watch it on our margarita things. You can switch around to H4 or H1 and then and file a 485. Yes, absolutely that can be done. We have done for several people like that.
Sri says, do I have to update my employer once I use my EAD and AP to complete the I-9 re-verification again? It is not necessary to do that. So the I-9 is the employer's responsibility, and the employer is only responsible to re-verify when your current employment authorization is expiring. So if you are on H-1B and you filled out your I-9 saying your H-1B status is good till 2025, you traveled and came back on AP and now you're using your EAD, the employer doesn't have to do anything until 2025 when your H-1B is going to expire, and at that time they'll ask you for updated employment authorization. Hopefully by then it's a green card, but if it's not, then you can provide them with your EAD.
Oh, Parth, Destiny of YouTube has, Facebook has this question. His fingerprints not good, rejected, what to do? Wow. The best thing right now is there are two things you can do. You can wait for them to recall you to go for the biometrics again, or what I would do is that I would walk to the biometrics place, tell them, look, you dummy guy, my biometrics have been rejected, can you do it again? And they will entertain you most of the time, and they will do the biometrics again. So I will do that, and at the most they will say, no sir, you cannot come in, you don't have a schedule, come back when you get scheduled, then you come back. But otherwise though, if they allow you, which they do 80% of the time, you just go and do the biometrics again. Now, let me tell you one thing, even if you do it again, if you get a request for the biometrics again though, go third time, okay? Just follow the directions. But I will try to make an attempt to go there.
B says, what's the current trend after the case is transferred to the National Benefits Center? How long is it taking for any action? So we're actually working on getting that data based on the post on immigrationgirl.com. We're adding a new column that shows you the date when it is transferred to the NBC, so you can see how long it's taking from that point to the approval. It's still in progress. Hopefully I'll have that posted next week. But I would say, just off the top of my head, probably 6 to 8 weeks from the time of transfer to the NBC is when we're seeing some of those approvals come in.
One exception, Emily, that I think so about is that you're only speaking about the approved cases,
yeah,
though. That how much time it's taking, not the amount of cases that have been transferred.
Yeah.
The similar way what USCIS is only telling the approved cases timelines. Yeah, the cases that we got approval, Emily is telling that 6 to 8 weeks is the time, but there are a lot of cases that have been transferred that may not be adjudicated though. B has this question. As per B has this question. As per the current trend, NBC, how much of the NBC cases are getting interviewed? Emily, I think so. 75% or plus of them are, especially in the last 2 weeks of the April, Emily, and to the May 2 weeks. I've noticed a lot more approvals without interview, though, as compared to what it was in the March and February. More number of cases are getting approved without interview right now. That's my observation.
Krishna says, using the AP doesn't mean I'm using the EAD, or are they two different things? So there is a memo that says if you have an H-1B or an L-1 or H-4 or L-2, and you use the advanced parole to return to the U.S. after a trip, you can continue your H or L status. And you do that by filing your H or L extension, and on approval of that, you are now back in H or L status. What that doesn't answer is what is your status from the day you enter to the time you get the extension approved. And that's where it's questionable whether you're actually in H or L, or are you using your EAD to work at that time. And we don't have a clear guidance on that, but I can say for sure, after you enter on the AP, if you wanted to, you could continue to extend your non-immigrant status, and the approval of that extension does put you back in the non-immigrant status, so you're not using your EAD from that point going forward.
Samhita has a very good question from Facebook. Why some of the I-94 extensions are given in the automatic revalidation successfully? Why some of them are not? At this point of time, Samhita, we do not have a clear data with regards to, we have only sporadic cases that got only allowed until what their current I-94 was there. We have noticed sometimes where people went to some airport like Baltimore Airport, that may be single isolated incident. Most of the time they said, oh, we don't have the technical things to do that. That's what they said. But then there are other people who went to the same airport that got those things approved. So maybe the officer doesn't know it, we don't know, but we don't have a clear data on that. But if people keep on supplying the data in the chat and other groups, then we will update it. But that's what the information we have right now. No clear indication why some people are getting and some people are not getting.
Avinash says, if working on the AOS EAD, do we need to file the 485J or use AC-21 to work from home for the same job with the same employer? So if your home is not within the same metropolitan area, then you could do that in order to keep your 485 going with respect to the new work location, because your 485 is based on the work location that's in your labor certification. Would you need to proactively do it? Maybe not. Maybe wait for an RFE, maybe wait until an interview, because there's no requirement to submit it in advance. I often submit it in advance in the hopes of avoiding an RFE because I don't want to delay things further, but you could go either way with that.
Question that comes from Krishna Reddy. If I get a green card, then I marry a girl from India, what options are available for me to bring her to USA? Unfortunately, the only option would be that you have to file a green card application, and the processing time will be anywhere between 2 to 3 years for her to get into this country. And what I recommend is that if you have maintained the non-immigrant status, this may be the right time for you to get married and get here on the H-4 visa, because H-4 visa is immediate and green card takes a long time and she cannot come into this country. And Krishna, we normally refuse to take the cases because whatever time we tell people and they annoy, the wife annoys me, the husband annoys me, the wife's mom's annoys me, the wife's mother-in-law annoys me, everybody annoys me saying, why is it taking longer time? The other friend got it, because they don't go in line all the time though. And it's very frustrating to keep the young couples separate. And I understand why they're calling me so frequently and frustrating me. I understand, because if I'm been there, I would do the same thing. So what I recommend for you, Krishna, because you are right to correct it right now, is that if you already have identified a girl, you better marry right now. Because to bring an H4, it's so easy. You don't pay that much money to any lawyer, boom, you bring the person here. But if you get married afterwards, it's going to be more costly, more frustrating, and not good for you, not good for her, not good for your immigration lawyer either, because he gets frustrated too. Believe me, I do.
MDPA says the EB2 filing was approved by the company, but with the prevailing wage, it only mentioned 4 years of experience, and now they're saying they can only file an EB3. No way to file an EB2. Is there any option to file an EB2? So I'm assuming with this experience requirement, it's based on a bachelor's degree. So if you have a bachelor's degree, in the prevailing wage, it says you have to also have 4 years of experience, not 5. Unfortunately, there's no way to proceed with EB2. In that situation, they would have to start a new prevailing wage, so that's going to take another 6 months before you can really get into the perm process. But to proceed with the existing bachelor's plus 4, they can only do it in EB3.
Kirti has Kirti from YouTube has this interesting question. Can I go to India? That means that she wants to do the automatic revalidation, but she wants to go to Canada, fly from Canada to India, come back to Canada, come back within 30 days. No, that is not automatic revalidation. You should not be allowed. It may be considered as illegal entry, will have long-term consequences even if the CBC officer allows it. Naveen Vimsai has this question. My priority date is November 2013. Should I interfile or refile? We put a very good video in March of 2022. We want you to watch that video. It's a 20-minute video. All questions answered only about interfiling and refiling. And if after, Naveen, if after you watch the 20-minute video, if you still cannot make the decision though, what I would suggest to you is that give a toss to your wife. Let her call the thing, heads, refile, tails, interfile. If she is correct and she gets everything correct and you get the green card very fast, I should get the credit. But if by any chance things turn out a little bit sour in that and the other people get faster than you, we both should blame your wife.
Uday says, my spouse got the H4 approved till 2025, but the H4 EAD is still pending. She wants to go to India for a couple of months and work from India till the end of August. Her current EAD is valid till the first week of August. Is that okay? Yes, no issues with that at all. Once she's in India, US immigration laws don't apply to her. She doesn't need an EAD to work in India. So she can wait there until the new EAD comes in and then come back into the US. But I mean, if her H4 has been approved till 2025, she has the I-94 for the H4 and her EAD is pending, she gets the automatic 540-day extension. So she doesn't lose her EAD in August. She can keep working if she wanted to. So if you're thinking you have to do that so that she can keep working, you don't have to do that anymore. In your case, because she has the H4 extension already approved, she has the valid I-94, she's already filed the EAD renewal before it expired. That's the exact circumstance where the 540-day automatic EAD extension exists.
Harry has this question that I-130 approval, then now the spouse has changed to Canadian citizenship. Will it negatively affect the remaining green card process? No, it will not negatively affect. It's the spouse, that alien spouse that acquired the Canadian citizenship. It does not negatively impact it. It's the same spouse, nothing has changed, just the citizenship has changed. It will not impact it.
Ram says, can I interfile from EB3 to EB2 with my old employer, still continue to work with both a new and an old employer at the same time? Does the 180-day rule apply in this case? Well, since you're still with the old employer, the fact that you're working for a second company has no relevancy at all, as long as you're authorized to work for them either through a concurrent H-1B or using your EAD. But because you have the old job still, you don't need AC-21. The 180-day rule doesn't need to kick in.
How long it's taking for the H-1B regular processing? Question from Shruti. It's taking anywhere between, there are some cases that have been approving in 2 to 3 weeks without premium processing. But there are some cases that are taking 8 months though. Good question from MDPA, a natural lover. Filing EB3 approved prevailing wage right now. Is it better to wait for a new prevailing wage that has a EB2 and it's going to take 8 months later, or should we file under EB3? I would do both. I mean, if you can, file an EB3 and then wait for the EB2 labor certification approval to file. It depends on a lot of different. If this is a first labor certification you're filing, go ahead and file the EB3, because assuming that you are from India, your prior date is not becoming current very soon. So getting the earlier priority date is very important for you rather than EB2 or EB3. You can always convert into EB2 later on. But if you are right now in a situation where your priority date, you have a previous priority date and you're now trying to port the date though, then I would recommend first file the EB3 and then you can file the EB2. Or if the company says, no, we are not going to file both labor certification, then you have to pick a coin toss, because I cannot tell which priority dates are going to move faster. You have to judge yourself based on how the things are moving.
Priya asks, will green cards be spilled over from the family-based to employment-based for the next fiscal year? For sure. I think there's a good chance of that. I mean, just based on the consulate still not operating fully, they're probably not going to be able to issue all the family-based green cards that they have available. How many extra will there be? We don't know, and we probably won't really know until October, basically. But there's definitely a possibility based on how slow they are in adjudicating those applications as well.
Amit has this question that the H-1B is automatically revoked. I moved on to the EAD in December of 2021. Is this concerning? There are two aspects of revocation, Amit. When the company withdraws the H-1B, because you moved on to the EAD application, the company might have withdrawn the H-1B. If that's the case though, which most probably it seems the case, because that's the only automatic revocation that I can think about, then you are under no trouble. That's perfectly okay. There are some cases where it's not automatically revoked. They issue an intent to revoke and they revoke it. That definitely a troublesome thing. But under your circumstances, based on what my understanding is, that you are good, no problem.
Sri has an EB2 I-140 approval, did the downgrade to EB3 in October 2020. The EB3 I-140 is still pending, and he wants to know, to do an interfile, is it just a letter? Is that sufficient, or do you need the supplement J? So before January of 2022, it was just a letter that we would explain that the person has these two I-140s, they qualify for both categories, submit the 485 receipt notice, the I-140 approval notice, the visa bulletin, and explain that they can transfer the underlying basis. But in January, they come up with this special way to do an interfiling so that they can track it better. And for that, they do ask that the 485 supplement J be submitted. So that's what we've been doing since that time, following their guidance.
Emily, I want a little bit discussion on this one, is that, and I have a consultation that's coming up tomorrow, which is bad, on the same issue though. Can I withdraw the EB3 downgrade amendment application file after using the advanced parole? Is a question from Subbu. Most probably he might have filed an EB2 485 application. That's the reason he wants to withdraw the EB3 application. There's a consultation that I had, I had a consultation before and I have a follow-up consultation again. This person had a EB2 485 application and EB5 485 application pending. And under the circumstances, I didn't wanted him to get an EB5 485 application approved, because if it's approved, it's only conditional, it's only valid for 2 years. So I told him, withdraw the EB5 485 application so that you don't get the green card, you get the green card under EB2. Guess what? Right now, I got an advance parole denial saying that they withdrew the EB2 while this guy withdrew, he got his 485, EB2 485 withdrawn instead of EB5. So the one that I want to get withdrawn did not. Now that's the reason, Subbu, when people have EB3s and EB2s, we do not recommend people withdrawing the EB3. Let it be as it is. It's not going to bother you. They will, if you withdraw it, EB3, they will just withdraw the EB2. I mean, that's exactly what they do. And there are a lot of different things when you try to do. You withdraw one I-140, what they will do is that there are some people who have an amendment pending, they withdraw the I-140. Guess what happens? They approve the amendment and then they withdraw it, and then you're doomed. You'll be good for nothing at that point of time. So I would suggest, when both cases are pending, do you suggest them to withdraw?
I would not.
Yeah, don't withdraw the EB3 application, guys. Now, in the other client information, because I said EB5, because I don't care whether the gentleman gets a EB3 or EB2, I will take it. But when it's a EB5 green card, though, I don't want EB5 green cards because it's only valid for 2 years. Then I have to apply for the conditional removal. Then it will take 6 years or 5 years for those conditions to be removed. So that's the reason I told him, let's get the EB2 green card. And he withdrew the EB5, and now EB2 got removed.
Yeah, it's real tough with USCIS following the instructions that you've sent to them. They get things mixed up very easily, unfortunately. And then what do you do in that situation? Try to reopen it and argue that?
Well, it's money for immigration lawyers, of course.
Yeah.
Questions from Abhishek. 2014 priority date downgrade, yes. October 2020, of course. Our company got acquired. What are our step to back to EB2? Assuming, Abid, if your new company is considered as a successor interest, that means that they have taken the assets and liabilities of you, though, they can file an EB2 application using the labor certification of the previous company, get the EB2 approved. They don't need to file a labor if they meet the successor of interest. Then you can consider whether you want to do interfiling or refiling, that step. But you need to file an amended EB2 approval immediately. You need to file a EB2 amendment immediately with the new acquired company. If they don't meet the successor of interest, which your lawyer, immigration lawyer, will be able to tell you, then the new company have to file the labor and I-140, get the EB2 approval, then do the interfiling or refiling.
Cigar says you filed the EB3 in October 2020 and then the Interfile in March 2022, and wants to know, can we put in a service request based on the October 2020 receipt date, since that's the same application? Yes, so your received date doesn't change just because you've interfiled, because you're basically keeping that same process going. Now, of course, the new service request requires you to plug in your received date and where it's pending and all of that, and what type of case it is, and then it will spit out a date that you can do a service request. So it may very likely be too early for them to accept one, even based on the October 2020 filing date.
Some people are having a good or bad comment. I don't know about it. Rahul does not sound like a lawyer. First of all, I take it as a compliment. Thank you for that. Before I became a lawyer, I was an immigration client. That's one thing, and that I claim to have a more responsible. But I am a lawyer. Don't forget that. Directly from high school, after 12th, I went to law school. I never went to any other school other than law school. We get a lot of people who have, who come to our views and they send, and they call our staff and then they say, hey, give us a free consultation. No, I mean, we have to live, guys. I mean, we have to have a consultation fees. We have to have those things, because otherwise, jab dannu ghas se pyar karega to khayega kya? Means when the horse fell in love with the grass, how can they live? So our livelihood is definitely is your patronage and your having consultation, giving us the cases. That definitely is not going to go. Of course, we do this service that really enhances our immigration lawyer capability, because the kind of questions that come here, the kind of ability we get because of your question and interaction is the best experience we both or our entire office can get it, which we cannot get it by just practicing law. Believe us, you are the motivational factors for us.
Abid says he had a 2014 priority date downgraded in October 2020. The company got acquired and wants to know what are the steps to get back to EB2. So because of the acquisition, the new company has to establish that it's a successor in interest to take advantage of that EB2 I-140, which means they have to amend the EB2 I-140, showing that they're still offering the same job in the same location, and that they have the ability to pay the salary from the date of acquisition going forward. So you can do that amendment and also request to transfer the underlying basis at the same time to the amended I-140, so that once it's approved, then you will be an EB2.
Anything else, Emily?
I think we're out of time today. Thanks so much for joining us, and we'll be back next Tuesday. Don't forget, you can check immigrationgirl.com for the latest updates and keep an eye on the tracking of the adjustment of status applications.
Thank you very much.